Today, I want to speak to you about the constitutional origins of the Supreme Court, the evolution of its powers, its history, and the importance of the justices in changing the meaning of the Constitution and the Bill of Rights. First, let's look at the Supreme Court's origins. When the framers created Article 3 of the U.S. Constitution in 1787, the judiciary was perceived as the least important, least powerful, and least political branch of America's tripartite governmental structure. To preserve its political independence, the court was purposely removed from the people. The 6 justices who comprised the first Supreme Court were not elected, but were instead appointed by a president who was selected by the Electoral College rather than a popular vote, and were confirmed by a Senate, which was indirectly elected by the 13 state legislatures. But this vision of a non-political Supreme Court with limited powers was not destined to last. The court's power, according to the constitutional framers, was restricted to such disputes as those involving federal questions arising under the Constitution, federal laws, or treaties. Disputes allowed to be resolved were limited to those arising between the United States and a state or a citizen, between or among the several states, or between citizens of one state against citizens from another state. In its earliest days, the court met in a rooming house for a few weeks, a couple of times per year, ready to hear any cases that never came before them. The job was so uninteresting that the first Chief Justice, John Jay, resigned to take a more interesting job, governor of New York. Despite the court's limited authority, the other branches in this new governmental system were empowered to affect the court's work. Presidents had the power of appointment of the court's members and have thus altered the decision-making direction. Congress was granted some checks and balances power over the justices through its power both to limit the Supreme Court's appellate jurisdiction and the number of its justices, as well as to create any additional inferior federal courts. Thus, in 1789, Congress created the lower federal court system of the district courts, in which trials, often jury trials as outlined in the Bill of Rights, would determine the facts in a legal dispute and render their decision. Then, an intermediate system, the courts of appeals, was created and empowered to decide appeals of those lower court decisions prior to a possible appeal to the Supreme Court. Most of those Supreme Court cases were compulsory appeals that had to be decided. Over time, the size and scope of responsibility of the Supreme Court has changed repeatedly and substantially. As a result, the power of the justices has mostly expanded, and their decisions have altered public policy. In 1803, Chief Justice John Marshall, appointed by President John Adams, helped to set the court on a path to greater power by establishing in Marbury versus Madison the power of judicial review. To frustrate his second cousin, President Thomas Jefferson, in a federal judicial appointment dispute, Marshall declared the court to be the final interpreter of the Constitution, thus giving itself the power to say no to the 2 political branches and be the final resolver of all constitutional issues. Marshall's successor as Chief Justice, Roger Brooke Taney, an appointee of President Andrew Jackson, reversed the early pro-federal government decisions and instead supported states' rights. But in 1857, Taney destroyed his reputation and that of the court and set the Supreme Court on a more political course by trying to resolve the issue of slavery and avoid the upcoming Civil War through his decision in Dred Scott versus Sanford. This highly controversial decision, which denied basic human rights to a former slave who had temporarily moved to a free state, helped to accelerate the advent of the Civil War and caused one of the dissenting justices, Benjamin R. Curtis, to quit the court in disgust, return to the practice of law in his native Boston, and eventually defend President Andrew Johnson in his Senate impeachment trial. The 3 Reconstruction Amendments, the 13th, 14th, and 15th Amendments, were passed and ratified in the post-Civil War period and sought to expand human rights and voting rights, but they also changed the power of the Supreme Court and the meaning of the Bill of Rights and the Constitution. Through the 14th Amendment, with its due process, equal protection, and privileges or immunities clauses, the court also explored whether some or all of the Bill of Rights written to limit the federal government could also be applied to the state governments. At the same time, the court considered whether Congress's power to regulate interstate commerce could be used by the federal government to regulate business enterprises and commerce between and even wholly within the states. After decades of very conservative decisions, which refused to apply nearly all of the Bill of Rights to the states and rejected the broad use of the federal government's Commerce Clause economic powers, the answer to all of these questions would eventually become a partial and then almost complete yes. As the country grew and its legal system and number of disputes expanded, the number of cases eligible for review by the court rose precipitously. In 1925, former U.S. President and then Chief Justice William Howard Taft persuaded Congress to pass the so-called Judicial Bill, empowering the court to limit and control much of its appellate docket by creating the discretionary writ of certiorari. This provision allowed the justices to refuse to accept an appeal if there were not at least 4 of the 9 justices agreeing to review it. This so-called Rule of 4, then, allowed the court to accept cases, and it still exists. Though after another congressional act in 1988, it is now used for nearly all of the court's appellate docket. Thus, the justices have total control to create their own agenda and regulate the timing of the issues they want to explore. They are now also able to pick the most appropriate cases to decide in order to give clear guidance to the lower courts, the legal community, and the state. After Franklin Delano Roosevelt became president in 1933, Congress created many New Deal programs that expanded federal power to alleviate the Great Depression of 1929. However, when FDR got no appointments to the court in his first term of office, the ultra-conservative Supreme Court under Chief Justice Charles Evans Hughes, nicknamed the 9 Old Men, used its power of judicial review to declare many of those New Deal relief laws to be unconstitutional abridgments of the authority of the state's powers under the 10th Amendment. This completely put the brakes on several programs supported by FDR in Congress to help resolve the Depression. Following his landslide re-election in 1937, Roosevelt proposed the Judicial Procedures Reform Act of 1937, nicknamed the Court Packing Law, which was presented to aid the elderly justices in their work, but also sought to add a new justice to the Supreme Court for each justice over the age of 70, up to a maximum of 15 justices on the court. At that time, there were only 6 justices at or above that age, including Chief Justice Charles Evans Hughes, and the ultra-conservative bloc called the Four Horsemen, James Clark McReynolds, Willis Vandevander, Pierce Butler, and George Sutherland. Ironically, the eldest of these old justices, Justice Louis D. Brandeis, who was then 81 years old, was not only the most liberal member of the court, but the most up-to-date in his work. This would have allowed FDR to appoint 6 pro-New Deal justices, all ideological allies that would sway the court's voting balance his way. In response, Chief Justice Hughes and Associate Justice Owen Roberts, who had previously voted with the conservatives, switched their votes in several subsequent commerce and business cases to reduce the necessity to pack the court. This voting strategy by them was nicknamed the switch in time that saved 9. It defeated FDR's plan and changed the direction of the court forever. 1 year later, those same justices would announce to the world that they were no longer in the business of regulating economic and business cases, but they were ready to now consider revising and extending and using the Bill of Rights to create individual rights in America. By the mid-20th century, the court, led by Chief Justice Earl Warren from 1954 through 1969, ruled in hundreds of cases per year, further expanding the power of the court, protecting individual rights, and increasing the federal government's authority over the state educational systems. In Brown v. Board of Education in 1954, the court unanimously voted to end Plessy versus Ferguson's separate but equal segregation of public schools, which had been established in 1896. In so doing, all of the justices unanimously reversed what they called the inherently unconstitutional Jim Crow policy of segregated schools. They also used social science evidence rather than strictly legal precedent to promote this political change. They were persuaded to do so by attorney Thurgood Marshall of the NAACP Legal Defense Fund, who would one day serve on that Supreme Court. 3 years later, a unanimous court integrated Central High School in Little Rock, Arkansas. In response, President Dwight D. Eisenhower sent federal troops to ensure that this ruling was enforced. After Presidents John F. Kennedy and Lyndon Johnson added more liberal justices to the court, it applied all but a few provisions of the Bill of Rights to the states. In so doing, the court appeared to have completed the federalization of the national government's powers over the states in order to preserve individual rights, even if they were not specifically written into the amendments. 4 conservative appointments to the court between 1969 and 1971 by Republican President Richard M. Nixon completely reversed the ideological direction of the court. As a result, many of the Warren Court's liberal rulings were limited or even completely overturned. However, that same court also created and protected the right of abortion in 1973, and a year later, in 1974, they ruled unanimously that President Nixon did not have an executive privilege power to keep presidential recordings of Oval Office discussions about the Watergate break-in away from the federal courts and a congressional investigating committee. Thus, the court that Nixon had filled with 4 appointments ended his presidency. Since 1970, only 4 justices have been appointed by Democratic Party presidents, while Republican Party presidents have appointed 15. For this reason, Republican appointees have continuously held the majority. However, several of those conservative appointees moderated over their time on the court, eventually voting with or even leading the liberal justices coalition. Still, the increasingly conservative voting majority overall, under 3 successive conservative Chief Justices, Warren Burger, William Rehnquist, and John Roberts, largely charted a much more conservative path for the Supreme Court. From 1986 to 2016, Justice Antonin Scalia led the conservatives and promoted his theory of adhering to the text of a law or the Constitution and interpreting them in accordance with his original public meaning of what the people in the constitutional founding era understood those words to mean at the time they were enacted. So Scalia argued that he was interpreting the Constitution and the Bill of Rights just as the people in Philadelphia's ratifying conventions did between 1788 and 1791. In fact, though, many of his rulings did nothing of the sort. While conservatives have often been described as opposing federal power, these conservative court majorities have been just as willing to increase their own judicial powers, just as the liberal justices did on the Warren Court in the 1960s. Nevertheless, occasional decision-making by a series of centrist justices on some social issues, such as the right of abortion, protections against the death penalty, the right of privacy against unreasonable electronic and cyber surveillance, and same-sex relationships and marriage rights, have created an increasingly conservative but not completely far-right court. The modern Supreme Court has protected the First Amendment's free speech and assembly rights, but for the freedom of religion rights, it has also largely erased the high wall of separation between church and state. During these years, the court has also drastically reduced the number of cases they agree to hear, despite having increased the number of law clerks they hire to help them do their work. The racial, gender, and religious representation on the court has shifted over time. For nearly all of the court's history, it was staffed by white, older, corporate-oriented, Protestant men. Between Chief Justice Roger Brooke Taney in 1835 through William Brennan in the 1950s and beyond, and until Justice Antonin Scalia in 1986, there was always only one Catholic justice. The court's first Jewish justice was Louis D. Brandeis, appointed by Woodrow Wilson in 1916. The first African-American justice, Thurgood Marshall, was appointed by Lyndon B. Johnson in 1967. Its first female justice, Sandra Day O'Connor, was appointed by Ronald Reagan in 1981. And President Barack Obama appointed the court's first Hispanic justice, Sonia Sotomayor, in 2009. Since 1985, however, there has been only one Protestant appointed to the court, Justice David Souter, who was appointed by George H.W. Bush in 1990. The others have been raised either as Roman Catholic or Jewish. Since 1981, there have been 4 more women appointed to the court: Justice Ruth Bader Ginsburg, Elena Kagan, Sonia Sotomayor, and Amy Coney Barrett. And there is still only one African American on the court, Justice Clarence Thomas. The current Roberts Court then has 6 men and 3 women, 1 Latina and 1 African American, and 6 Roman Catholics, 2 Jewish justices, and Neil Gorsuch, who was raised Catholic, but he currently attends the Episcopal Church. Just where the court will go next and which 60 to 70 cases they will decide from roughly 7,000 to 8,000 appeals a year depends on which justice or coalition of justices controls the voting center of the body. All it takes is 5, Justice William Brennan used to say to his law clerks while wiggling his fingers in the air. Just give me the names of those 5 justices, and we might be able to do anything that they want. Just who those 5 justices might be will depend on which justices have changed their mind on an issue, which justices find a way to work with other members on a particular decision, just how theories of the justices have evolved, and whether justices get sick, retire, or die. In the last case, it will matter greatly who is the president at a time a vacancy is created, and what is the political voting majority of the Senate, as to how the voting in that open seat might change the court's direction. So, you can study the court and predict where it might go on the next constitutional issues by counting the size of the blocks of justices and determining who is in the middle on that case. How many conservatives are there on the court? How many liberals are there? Who are the justices who will tip the vote to a majority? They are the ones whose vote or votes need to be understood more completely. If you can count to 5, you can study the Supreme Court and constitutional law. Since 1974, nearly a half a century, if you could predict where the court's centrist justices, Lewis Powell between 1974 and 1987, Sandra Day O'Connor between 1989 and 2006, Anthony Kennedy between 2006 and 2018, and then Chief Justice Roberts since then, each of whom controlled the voting majority on many issues, you could predict how the court would rule. But now, as a result of the 3 appointments by President Donald Trump, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, the ruling centrist justices might come from some combination of their votes combined with Chief Justice Roberts. For now, the court seems to be roughly a 3-3-3 split, with Chief Justice Roberts, Justice Kavanaugh, and Justice Barrett largely controlling the voting in the middle. However, at times, the more conservative Justice Neil Gorsuch of Colorado occasionally tips the balance as well. This unique getting to 5 legal math makes studying and teaching current day decisions endlessly interesting. I hope that these thoughts will help your study of the Supreme Court and the Constitution. Understanding what each decision means and how it will change over time is very important, because each of those decisions change your rights, change our government, and greatly affect our American democracy. Thank you.